Hello students and welcome to the lecture. So students, as we know that we are covering the fundamental rights, okay? And basically in the previous lecture we had done with the article 22 and we have taken the preventive detention cases. Okay? So that's the thing that we have taken here. All right? And even we had taken a normalized overview of article 23. All right. So that is the thing that we have done in the previous lecture. I hope that you have revised the previous lecture in the well enough manner before you have come for this lecture. As many a times I have told you, that is for your own benefit. So if you are doing this on the regular basis, the thing will be far more beneficial for you. If you are not doing this on the regular basis, then you will face some difficulty while attempting the questions in your examination. Okay. So with this note, let's start this lecture from where we had left. Okay. So now we are going to see the fundamental right against exploitation. Okay. So it is the prohibition of traffic in human beings and the forced labor. Okay. And this is powered by Article 23. Okay. So if we start a discussion over it, so there is Article 23 of our Indian Constitution that prohibits the traffics in human beings, beggar, the forced labor. Beggar, basically, it's not beggar. Okay. Even I mistakenly pronounce it as a beggar. Okay. Because if we talk about the beggar, so it's the spelling. All right. This is the spelling of beggar. But here it is as a begar. Begar means the forced labor, which is also known as in some part of India as a bandua mazdoor. Okay. And other similar forms of forced labor. Okay. Any contravention of this provision shall be an offense punishable in accordance with the law. This right is available to both citizens and non-citizens. So basically, if we talk about this law, then we must connect it with the historical part. Okay. Then only we will be able to take it further. Okay. So if we talk about the historical part, so basically, the zamindars, okay, thereafter the Britishers, okay, and other kind of noble positions. Okay, so these were the powerful figures in the historical times, and they always used to grant loans to people with heavy interest and hard terms for repayment. They grant loan to people with heavy interest and hard terms for repayment. Okay, so because of this, what usually happened? Like the people who had taken the loan from them, they were unable to repay it. Okay, and because they were unable to repay it, usually the people were forced to sign the बेकार और बंधुआ agreement. Okay, so because the one who was failed to get to repay the loan, the person is required to do the work on the lands of noble politicians, zamindars, and the plantations of the Britishers for free. It means that they were not going to pay any single penny to them. Okay, and even this is described as a forced labor. Why? Because the abused was common with those labors. Okay, so that's the thing. So because in history we had to face such kind of things, that's why when we got independent and when we you can say what to make a independent and the free country, so we first thing what we did is to ban these kind of things. Okay, so basically we prohibited by the virtue of article 23 any human beings to be work as a bekar or the bandua and other similar forms of forced labors. And if any contravention happened to this kind of thing, then this will be an offense punishable in accordance with the law. And this right is available for both whether the citizen of India or whether the migrants or the non-citizens of this country. Okay, because here we have says the human being, not the specific citizens only. So basically it protects the individual not only against the state but also against the private person. It means the state and its authorities and even the private persons who having the influence in the society, they could not use the human beings for the you can say as a forced labor for the work in some different areas. The expression traffic in human beings include what? It's a broad term like selling and buying of man, women and children like the goods. Okay. Thereafter, immoral traffic in women and children including the prostitution. Thereafter, devdasis and slavery. Okay. It means that no person, whether in a state authority or a private person, is allowed to use the human beings in any of these businesses. Like no human being, whether a man, woman or children, could be sell or buy it as a good. No human being like a woman and children could be you can say indulge into the prostitution by force. Devdasis and slavery is also punishable offense now. To punish this act, the parliament has made the one act which is known as the Immoral Traffic Prevention Act 1956. Again, we have got an important question. Like if the question asks, Immoral Traffic Prevention Act 1956 has been enacted by which fundamental article? So the answer should be Article 23. Similarly, if the question gets reversed, like instead of this, the question will be Article 23 leads to the establishment of some particular act. Which of the following is the right answer? So the answer is Immoral Traffic Prevention Act 1956. Okay, it means that the question could be reversed, but the concept will be the same. All right. Thereafter, the term bekar means compulsory work without any remuneration. Okay, which is sometimes also known as bandhua. And the story behind it, I had told you. If the person who had taken the loan from the nobles, zamindars, or the Britishers get failed to repay it, then the person would become liable to work in their fields, to work for them without any remuneration, or you can say work for free. Okay. Thereafter, it was peculiar Indian system under which the local zamindars sometimes used to force their teenagers to render services without any payment. Okay. In the historical scenarios of this country. Okay. In addition to Begar, the Article 23 prohibits the other similar forms of forced labor, like the bonded labor. Okay. this is also prohibited. Thereafter, the term forced labor means the compelling a person to work against his will. Okay, like the person do not want to work with you, but now you have forced it to work for you. All right, then this will be compared as a forced labor, or you can say bekar or bandhuwa. Okay, so the word force include not only physically or legal force, but also force arising from the compulsion of economic circumstances, that is working for less than the minimum wage. Okay, for example, if we talk about some backward areas or some remote areas, if we talk about it. Okay, so there is a word which is known as the wages or dihadi. In Hindi it is known as the dihadi, and in English it is known as the wages. Okay, so what is this? Like, this is the remuneration given to the person who works for you a day. All right, so if we talk about the you can say majority portion of this country. Okay, so usually it is ranges between rupees 350 to 400. That is a general range for labors. Okay, like if there is any contractor who had employed someone for a labor, and if the employed labor worked for a day, then in the end of the day the contractor is required to pay at least 350 to 400 rupees to the person as a dihadi or as the wages. Okay, so if the contractor refused to pay this amount, and instead of this he is only paying the rupees 100 or 250, okay, then it is far below the minimum wages. Okay, it is far below the minimum wages. So what will happen? This will be considered as a forced labor. Okay, so we could say that the forced labor having the two aspects, basically physical abuse or the financial crunch. Okay, so any of these things if happen with the person, then this will be considered as a forced labor. All right, but now the question is, how does the minimum wage will be decided? Why? Because if we talk about the country, then the country having the diversity. Okay, so this is quite common that wages range different at different places. Wages stand different at the different places. Okay, so because of this, just because of this, what happened? Like, there are some acts which are required to be passed off. Okay, so in this regard, the acts are like Bonded Labor System Act 1976. Okay, Minimum Wages Act 1948, Contract Labor Act 1970 or Equal Remuneration Act 1976. Okay, so these were some of the acts which were made in this regard so that the forced labor could be stopped, and even the adequate wage or the minimum wages could be defined towards the country with uniformity up to some extent. All right, this is the thing. Thereafter, Article 23 also provides for an exception to this provision. Why? Because we know these are not absolute but qualified. Okay, so the restrictions, or you can say exception, could be granted. Okay, so basically there are some exceptions. The first is that it permits the state to impose compulsory service for the public purposes, for example military service or social service, for which it is not bound to pay. Okay, it means that if the government feels it is necessary that every individual, whether he or she wants or whether he or she not wants, to render the military service, then it could be happen. Similar with the social service also, and the government is not bound to pay any single penny for those kind of services. Okay, thereafter, however, in imposing such service, the state is not permitted to make any discrimination on grounds only of religion, race, caste, or class. It means that the government have no right that they said only that particular religion, that particular race, that particular caste, or that particular class could join the military service or the social service. And even the government could not exclude any particular religion, race, caste, or class from the services just because of these reasons. Okay, so any inclusion or you can say exclusion based off these are you can say prohibited. After this, the second one is the prohibition of employment of children in factories, etc. This is Article 24. Okay, so basically, if we look at here, so we could see that the Article 24 prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activities like construction, work, or railway. Okay, it means that if the children is not even reached the age of teenager or not an adolescent, then the particular child could not be employed in any factory, mine, hazardous activities, or the construction of work of a railway. Okay, but it does not prohibit their employment in any harmless or the innocent work. Okay, it means that the child, you can say the children's uh, employment is only prohibited in the hazardous works or the dangerous work, but in the harmless or the innocent works, they are allowed to do the work. The Child Labor Prohibition and Regulation Act 1986 is most important law in this direction. Again, we have find a question. Okay, like the question will be asked in the examination. The Child Labor Prohibition and the Regulation Act 1986 has been passed under which article? So the answer should be Article 24. Similarly, the question could be asked like Article 24 leads to the passing of which of the particular act. So the answer is the Child Labor Prohibition and the Regulation Act 1986. Okay. This is the thing. Thereafter, in addition to this, the Employment of Children Act 1938, that has been passed. Factories Act 1948, that was passed. The Mines Act 1952, that was passed. The Merchant Shipping Act 1958, that was passed. The Plantation Labor Act 1951, that was passed. The Motors Transport Workers Act 1951, Apprentice Act 1961, Beedi and Cigar Workers Act 1976, and various other similar acts prohibits the employment of children below certain age. Okay, and if you look at all these acts, so these acts were basically done to prevent the employment of child in hazardous or dangerous work. Okay, this is the thing. Thereafter, it was the year of 1996 when the Supreme Court directed the establishment of Child Labor Rehabilitation Welfare Fund, in which the offending employer should deposit rupees 20,000 for each child employed by him. Okay, like this is the penalty. The acts were there. But we know when any act got violated, okay, when any act got violated, then what is the thing happens here? Like there is a some prescribed punishment or penalty. Okay, there is some prescribed punishment or penalty. All right. So basically, for this, the Supreme Court in the 1996 said that there must be some fund which is known as the Child Labor Rehabilitation Welfare Fund. Okay, and this fund will be the sink zone of collected, you can say penalties, sink zone of collected penalties from the violators. Okay, and if we go by this, so basically it is child labor rehabilitation welfare fund, right? And there is a penalty of rupees 20,000. Okay, rupees 20,000 per child. Okay, so if we go by this, then what we will find? Suppose if there is any Mr. X and he had employed 20 children which were in the age group of 18, okay, let me make it 8 to 14 years. Okay, so if we look at here, so what do you think? Is it as per the law or not? So basically, this is the well-defined violation of the law. Okay, so what will happen? He had violated the law. Now it's a time for penalty. So how much penalty is to be required? So that is 20 students were employed, 20 children were employed, and it's 20,000 per child. So what will happen? The total penalty would be 40,000. Sorry, not 40,000. Basically 4 lakh. Okay, so rupees 4 lakhs will be the total penalty amount chargeable on Mr. X for the violation of the act. Okay, and because as I have told you, that will be the sinking zone. Okay, so this 4 lakhs will be given to the Child Labor Rehabilitation Welfare Fund. Okay, and here this amount will be used for the various welfare, you can say, works and various rehabilitation work for those children who get into the works as a forced labor and who had become the victim of child labor. All right, so that's the thing. And please remember the date of judgment. The date of judgment is the 1996, and basically it was passed on by the Supreme Court. Okay, it also issued the directions for the improvement of education, health, and the nutrition of the child. Okay, and the Commission for Protection of Child Rights Act 2005. Remember this? The Commission for Protection of Child Rights Act 2005 was enacted, and this basically led to the establishment of a National Commission and State Commission for Protection of Child Rights and the Children's Court for providing speedy trial of offences against the children of a violation of children's rights. Okay, so this is done for that particular things. Okay, thereafter in 2006, the government banned the employment of children as a domestic servants or workers in business establishments like the hotels, dhabas, restaurants, shops, factories, resort, spas, tea shops, and so on. Okay, like this is basically the non-hazardous or non-dangerous works, right? All right. So basically, even the employment in non-hazardous or non-dangerous works prohibited by the court in 2006. Sorry, by the government in 2006. Okay. And basically, they want that anyone employing children below 14 years of age would be liable for the prosecution and the penal action. Okay. The child labor, thereafter, the Child Labor Prohibition and Regulation Amendment Act 2016 basically amended the Child Labor Prohibition and the Regulation Act 1986 and then renamed the Principal Act as the Child and the Adolescent Labor Prohibition and the Regulation Act 1986. It means that not only the child but also the adolescent will be considered in the new directions. Okay, so this is the thing. So students, basically in this lecture we have done till here. In the next lecture we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture, and what we say thank you.